So we got a clearer picture of the case each side is attempting to lay out before this jury. Prosecutors allege Trump took part in a criminal cover-up to conceal that hush money payment. They said his actions were, quote, election fraud, pure and simple. The defense pushing back against that argument. Trump's team said there was nothing wrong with trying to sway an election, saying, quote, that's called democracy. Kevin McMunigal is a law professor at Case Western Reserve University. Kevin, or should I call you Professor? Thanks so much for joining.
Just call me Kevin. Nice to see you.
Well, Kevin, listening to our first sample of both the defense and the prosecution case today, who ended the day with the advantage, in your view?
In my view, the prosecution did. They emphasized conspiracy and cover-up, which I think is their main theme. The defense, it seems like they're conceding the facts, and they're just saying, well, look, this didn't constitute a crime. And they're going to analogize it to say, well, look, people enter into non-disclosure agreements all the time and pay money to people to not disclose. That happened with a lot of people in the Harvey Weinstein case. So it's not inherently illegal to have a non-disclosure agreement. So, but the prosecution, I think, did a good job of emphasizing the number of people involved. You have Pecker, Cohen, Trump, and the intent to commit these, to cover up or assist these various crimes.
Okay, so tell us then, what is the legal threshold here? What does the prosecution have to prove beyond a reasonable doubt to distinguish between what it says was in effect a criminal conspiracy and what the defense says is just a legal attempt to influence the election by a candidate for office, but someone who is also trying to protect his reputation in general?
Yeah, well, clearly the prosecution has a high standard of proof beyond reasonable doubt. And they also have the burden of proof. They're the ones that have to provide the evidence. So that's, a significant threshold to meet. But prosecutors do it all the time. And I think in this case, the evidence just seems incredibly strong.
They say that they have, first of all, you look at the line of witnesses, David Pecker, former National Enquirer publisher and friend of Donald Trump, we should note. Michael Cohen, former lawyer and fixer for Donald Trump, although, of course, they've fallen out with each other. Karen McDougal, who will also apparently testify to other payments made to keep her quiet. Hope Hicks, who served in the Trump administration. Beyond that lineup of witnesses, they say they have receipts, business receipts, but also text messages, and even a recording of Donald Trump himself describing this scheme. How big an advantage is that for the prosecution as they attempt to prove that case?
Well, something that I was taught early on as a prosecutor is if you're going to call witnesses that have bias issues, as Cohen clearly does, he doesn't like Trump, so that would undermine his testimony. And also, he's lied in the past, so that doesn't make him a terribly great witness. But the key to that is providing corroboration. And that's the emails, the documents, the testimony of the other witnesses. And so I feel like the prosecution has, heeded that lesson, and they're using corroboration as a way to answer the problem. In the closing argument, they're going to say, it's not just you having to accept Cohen's testimony on its own. You have to think of it in the context of all this other evidence, which corroborates what he was saying, and some of which Trump has admitted. So that idea of corroboration with shady witnesses is a strong one.
A lot has been made leading up to the trial about the legal leap that prosecutors are making here to take what some say might typically be a misdemeanor, turn it into a felony by connecting it to a federal crime here. Is that a complicated legal step in your view?
I don't think it is. No, I think the law is pretty clear that predicate offense, the object offense, can be federal or state. And they've got a whole range of potential predicate offenses they can use. There's tax ones, there's New York election law, federal election law. So I think one of the strengths of the prosecution is they haven't tied their theory to just one object crime. they have multiple ones they can use. And they weren't terribly specific about it in the opening statement, and I think that's because they have some leeway about what the object crimes could be, and they may well be able to prove more than one. They only need to prove more, and they just need to prove the intent to commit that crime, not the actual commission of it. So that makes it a little easier.
Professor Kevin McMunigal, thanks so much for joining.